Okay, and welcome to Chapter 3 for CNM Fall 2019 AEMT course. This course is going to be on medical, legal, and ethical issues. While it's going to seem like it's kind of dry, this is probably one of the more important operational things that we want to know about. So if you guys are going to pay attention, make sure that we're looking primarily at consent and refusals, right? Because that seems to be some of the harder subjects to come upon. So here are some of the bigger subjects in med, legal, and ethics. The first being consent and refusal of care, confidentiality, advanced directives, tort and criminal actions, evidence preservation, and statutory responsibilities. Mandatory reporting, ethical principles, moral obligations, and end-of-life issues. So we all kind of know what the Hippocratic Oath is, and that's to do no harm, right? And so we really want to say to do no further harm, because some harm was actually caused to that patient that you're dealing with, and we're trying to mitigate that and get them the definitive care. As the slide says, litigation against EMS is going to likely increase. That's just a fact of modern society. Litigation is one of the ways that people seek retribution when they're angry or they feel that they've been wronged, whether or not you have actually created that wrong or not. By being party to it or involved in it in some manner, it opens you up to litigation yourself. There are some very specific ideas in litigation and what your responsibilities are and where you are liable, but we'll get into that a little bit further in just a little while. Ethical issues, I mean, we all have morals and ethics, and the two are heavily intertwined. You could almost say they mean the same thing. When emergency medical care is properly rendered, you can still get sued. Again, people tend to want to have that retribution or some kind of satisfaction when they feel that some kind of harm has been done to them against their will. And just because you're in the middle of that actual treatment algorithm from the incident happening until they feel like they're complete again, you can just be sucked right into the middle of that situation. Scope of practice. Scope of practice is not just like, hey, this is what you can and can't do, but it is a very definitive guideline that is legal in so much as that the state actually spells out what you're able to do. And again, if you reference the previous chapters, I have mentioned several times that the federal government basically paints with a broad brush and it sets the outside parameters. And as that legal jurisdiction becomes smaller and smaller, the only result is a tightening or a constricting of the scope of practice. Again, our state scope of practice is defined by the state law, and the medical director can further tighten or constrict those things, or more, I guess, clearly define the specific procedures, right? So anything outside of the normal state scope of practice is going to be considered a special skill. We have a couple of different ways to go about your scope of practice, and that is going to be online and offline medical control, and the medical director is going to have that ability to give you further orders either directly or by standing orders. So in the Bernalillo County area, we actually don't even call that a scope of practice. So your medical director can authorize certain procedures or skills, medical treatments based on online or offline medical control. Online being that you have direct communication with that particular medical director, and offline by a set of standing orders or protocols. In the Bernalillo County area, we actually don't call them protocols anymore, we call them guidelines, because we expect people to operate within a set of principles that were guided by the state scope of practice, and the guidelines are for us to look at the situation and evaluate the appropriate treatment. So it's not a step-by-step process. If you're looking for a cookbook, that happens in some particular areas, but in our local system, it is very much up to the user to assess and determine the appropriate treatment based on what they're evaluating and have diagnosed in the patient. So if you carry out procedures, like do things that are not approved for your license level, or you're using medications that you're not approved to use, you can be considered negligent, and it can be a criminal offense, right? So there are several different forms of negligence. I'm not going to get into those in this particular lecture, but if you are willful in the way that you treat a patient outside of your guidelines or your scope of practice as defined by the state, that can be determined as criminally negligible. And if you're found criminally negligible, that is when you can actually be pushed outside of the umbrella of protection by the employer or the agency that you work for. So standards of care, the manner in which you're required to act or behave, right? This is very simply put together in a manner with, if you were to ask 100 of the exact same level EMTs how they would treat that particular patient, they would all answer in a similar fashion. That by de facto becomes the standard of care, and if you reference back to previous chapters, that is something in which we speak about people being taught to a very similar level, and it's standardized across the US. So for the most part, barring the individual scopes of practice that may have been constricted, you should be able to go to New York and ask an EMT basic what they believe the standard of care is for a gunshot wound, ultimately getting the same answer out of an EMTB in California. Whether or not they're able to complete some of those actions, if you're just going by a national standard, that is our standard of care. We have to be concerned about the safety and welfare of others when your behavior has the potential to cause harm. If you're responding to an emergency call in an unsafe manner and you're not using due regard or due diligence to get to your call, you can be held liable. The same is held true for your ability to practice medicine. If you're reckless in the way that you treat your patients and you cause harm, you can be held negligible in the court of law. The standards of care are established by public medical research, the local customs, what we believe the appropriate treatment is for people, which kind of changes from culture to culture to culture, and then law. And most laws are based on cultural norms for the society that it serves. One particular law is the EMTALA Act, which is Emergency Medical Treatment and Active Labor Act. This is a very specific law in regards to your requirement to treat somebody once you've initiated contact with them as a professional. This applies all the way up to the hospitals and their required performance of medical care and treatment for life-saving measures on any patient who is in their facility or on their grounds. And it can get really, really spelled out, so if you're interested in that particular law, please do look it up, understand it, because everyone in the medical industry has to abide by that. There are some other established standards of care, and this is professional or institutional standards. And a couple of them are just the ability to perform CPR. One of those would be the AHA. The AHA is known as basically the regulating body on CPR. They are the ones that have determined the science behind all of the changes that happen, and their guidelines are pretty much used as the standard of care for any kind of CPR situation, coast to coast in the United States. The state can regulate based on the agencies, and that would be the Department of Health, and then the EMS Bureau for whatever state it is that you're working with. And again, this still boils down to perhaps just the medical control board for the particular system that you're working on. The initial standards are basically imposed by textbooks. This is the federal level. The federal laws that are put into place dictate what the educational institution is going to create in textbook, and then the legislation federally helps kind of shift all of those things as needed based on the evidence guidelines for negligence. Failure to provide the same care that a person with similar training would provide. Gross negligence is conduct that constitutes a willful or reckless disregard for a duty. There's 3 categories: malfeasance, nonfeasance, and res ispa loquitur, which the thing speaks for itself. Now I'm going to make this really, really simple. Gross negligence is going to be very similar to criminal negligence. Gross negligence is the willful or reckless disregard for duty. So if you knowingly perform something outside of your scope of practice that you absolutely know is not something that you should be doing, that is gross negligence and can become criminal negligence. This will also pull you outside of the protection umbrella of the agency that you work for in regards to lawsuits. You can become personally liable very quickly in that kind of a situation. All 4 of the following elements must be present for negligence to apply, and that's duty. And duty is the duty to act. If you're on duty and you're being paid to respond, you have a duty to act. You cannot ignore a dispatch from the dispatching authority to somebody's emergency. You have to arrive and render aid if at all possible. That breach of duty is if you willfully choose to not respond, or you willfully choose to not treat that patient who is asking for that help or that medical treatment. And then any kind of damages that are as a result of your duty to act, the breach of duty, and if they can find a proximate causation, meaning that you had a very specific role in the damage that the patient suffered by your lack of action or failure of duty to act. Abandonment, the termination of care by the AEMT without the patient's consent. And we can just make this a simple situation. Somebody asks you for help and you refuse to take them to the hospital. If you just decide that you're going to leave and you leave that patient in their home, that is abandonment. That is against the law. We have very specific legislation that says that if we're called and that patient wants to be transported to a hospital or requests some kind of treatment, you must render that aid, and you have to do so in the best interest of the patient. Once care started, you have to assume that the duty cannot stop until an equally competent person or a higher level trained person assumes that responsibility. So in retrospect to the previous chapters, if you show up and you're an EMTB, they can only give it to another person that's an EMTB or higher, or in your case it would be you as the AEMT, and you would turn over care to a paramedic, nurse, physician's assistant, or medical doctor. Abandonment is a legally and ethically serious matter that can result in civil or criminal liability. Again, if you willfully breach the standard of care, the duty to act, it can become a criminal liability. And abandonment can take place at scene or in the emergency department, which for further explanation means you can't just show up to an emergency department and have that staff tell you that you're going to need to stay with your patient for a little while until they can filter through triage and get the patient situated in an appropriate manner. If you just say put your patient in a chair and then just go on back out to the rig, leaving that patient without a proper turnover to the appropriate person, you can be found negligent in abandoning your patient. It would seem counterintuitive because you brought them to definitive care, but if somebody doesn't actually know what's going on with that patient, there can be harm caused by your actions or inability to get the person who's going to take over their care the proper information that is needed. Now we're going to talk about assault and battery, and the two terms are often confused or conflated. Assault is often used in the actual physical harm that's caused by touching of another person, when in fact it's the threatening or causing fear of a person in any regards to immediate bodily harm without consent. Battery is the actual touching or causing harm to that person, which for all intents and purposes can be just you creating harm to a patient by not obtaining their consent to provide treatment. So if you just assume that you're going to start an IV without giving somebody the ability to choose their treatment and you cause harm to them, that is technically battery. It can also be civil or criminal in nature. Kidnapping and false imprisonment. Kidnapping is seizing, confining, abducting, or carrying away by force. Now, in regards to EMS, that is taking somebody against their will to be treated when they're adamant that they're not going to be treated. And it's not very common in EMS because most people call us when they need us. Occasionally you may have a patient who didn't call, somebody else called for them, and they're refusing treatment, but we'll get into the refusal section in a little bit. False imprisonment is a little bit more likely than being charged with kidnapping because you're keeping possession of them instead of unexpected taking of their liberty. Defamation, slander, and libel. Defamation is the intentional making a false statement through written or verbal communication that injures a person's good name or reputation. Now this might be something where you're on scene and you tell somebody else on scene out loud, hey, this guy's a drunk. Or you may say something else similar in nature and not have the ability to actually determine that. As EMTs, we are not trained in the absolute ability to determine whether or not somebody's intoxicated. We can only make the inference that somebody may be intoxicated based on the things that we are trained to observe that fall into line with consistent signs and symptoms of intoxication. Libel is making that false statement in a written form. So if you write in your documentation on your chart, John Doe was drunk at the bus stop, that can technically be considered libel because of the inability for you to determine whether or not somebody was intoxicated. Slander is the false verbal statement, which means that you knowingly made a statement that was incorrect about somebody and you said it out loud to others. Good Samaritan laws and immunity. If you reasonably help another person, you will not be held liable for errors or omissions made in good faith for emergency care. So where we're going with that is if you are doing the thing that's right for your patient and a negative outcome comes, for the most part you're going to be held non-liable because of Good Samaritan laws. And this only applies if you're acting in the best faith to your training. And if you have no training and you're just trying to help somebody, you're generally held completely unliable as long as you're not being reckless. Now, those do not protect you from being involved in a lawsuit, but for the most part, they are kind of like a blanket of immunity. And when you come up state to state to state or local jurisdiction, those laws can change based on the customs of the people around you. So there's another group of laws that grant immunity from liability to official providers, and that's called sovereign immunity. It identifies limited types of lawsuits that can be filed against government agencies. So if you work for a metropolitan or a county or what have you, fire department, because you fall inside the government confines, you are actually protected by law from being held personally liable. And the other section of that is that there are very specific caps and limitations to the amount of damages that can be awarded from the government to a plaintiff. So now we're going to talk about consent for treatment. And consent literally means permission for treatment, right? So it's required from every patient that's mentally competent and an adult before care can be started. And this is something that culturally we see a very strong lack of because it becomes very complacent in the idea that somebody called you for treatment and they want help or assistance to definitive care. and we tend to just roll through the treatment algorithm without explaining these things to our patients. That's really not something that we should be doing. There should be consent for treatment on just about everything that you want to do. It's really hard to kind of get into that muscle memory, but it's really important and specific to EMS. If the patient's alert and rational and they can make an informed decision, they have the right to choose, and in most cases, they have the right to refuse any and all treatment. So if you're going to start an IV and you have a patient who is mentally capable of making that decision, you have an obligation to explain to them what you're about to do and then why you want to do that treatment. You also have the obligation of explaining to them any risks that may come of it. And if they choose at that point that they do not want that treatment, you have to respect that. Now, this requires decision-making capacity, and this seems to be kind of a very gray area. And I know a lot of us were trained, like, let's do the alert and oriented times 4. And alert and oriented times 4 is, for most parts, a good parlor trick, but it doesn't really give us a whole lot of rationale in whether or not somebody has good decision-making capabilities. All too often, we're able to ask people what time, what place, who they are, and what's happening to them, and they can regurgitate that, but they may not still be able to make a rational decision. And so this really comes under the provider, the AEMT, in regards to who's going to be determining whether or not they have that capability. And you should have that conversation with your patient. And if they seem like they're unable to make a good, solid decision, you should always default to dealing with the medical control, and whether that is you calling for an MSEP or using your standard protocols or standing orders to continue care. Talk to your patient. Find out if they understand what you're talking about. Just because they know the date and they know what happened to them, that doesn't necessarily mean that they can really make that decision. So we're going to talk about a couple of different types of consent. There's expressed consent, which the patient acknowledges that he or she wants you to provide care or transport. Right? So this is you talking to your patient, and you say, would you like me to take you to the hospital by ambulance today? And that patient says, yes, I would like to go to the hospital by ambulance today. They don't have to say it verbally. They can just express it in a head shake. You don't have to have them regurgitate the words. They just have to be able to agree to your treatment and transport. They have to be of legal age, and they have to be able to make that rational decision. So again, we're going to stress that it's not just an A&O times 4 thing. This is have a conversation with your patient. Make sure that they understand the things that you're saying to them. They may agree to certain emergency care, but not other care. So to put that in a little bit of a different layman's term, they might say, I would like a ride to the hospital, and you have determined that they could really use an IV for dehydration or medication administration. They still have the ability to say no to that particular piece of care. The next one is implied consent, and this is appropriate when your patient is unresponsive, they're delusional, or exhibiting some kind of altered mental status. They're basically unable to make an informed decision at that point. So again, we want to try to stay away from just specifically using the A&O times 4, because there are plenty of people who are intoxicated to a degree. They still can answer those questions appropriately, but they cannot make a rational decision about their care. That person probably needs to have some kind of an MSEP consult so that you can imply some consent and actually treat them and transport them against their will. Always defer to your medical director before you make the decision to do that. If they are delusional because of some kind of mental incapacity, be that biological or genetic, you also want to make sure that you're dealing with some kind of medical control that can help you make that decision to transport them against their will. Again, it's always going to be based on what's in the best interest for the patient and what doesn't violate their rights. If they're unresponsive, we're going to use the obvious situation in which somebody would rationally make the decision to have treatment. right? So if we have a person who has had a pretty significant or high mechanism car accident and they are currently unconscious, if they were awake and rational, would they want to be treated for their injuries? And so that one's a pretty much easy one to go against. It's just, you know, most normal people would want treatment for their injuries, and so we're going to use the fact that they're unresponsive as implied consent. So this is limited to real true emergencies. This, again, the person who's unconscious because of a significant trauma, maybe they're unconscious because they're experiencing some kind of overdose on opiates and it has their mentation basically at an unconscious level. It may only respond to pain, but not in any fluid manner. So you've got to make sure that you document this. It has to be thorough. You have to make sure that you've crossed all your T's and dotted your I's in regards to why you performed the treatments you did without them specifically telling you yes. If you can't get that person to give you consent for treatment, make sure that you're trying to get it from some family member. They also can refuse care as an implication, right? So implied consent no longer applies if the patient regains consciousness and appears capable. And a pretty specific situation for us in the local area, and it's actually in our protocols, is if we respond to somebody who has a opiate overdose and they are initially unresponsive, and we give them a medication and they wake up and now are alert and oriented and capable of making rational decisions, they can now refuse any further treatment or care. So that means that, you know, they don't have to have any more medication, they don't have to have the ride to the hospital. This also would apply to a diabetic emergency where we show up, somebody's unconscious, they're maybe responsive only to pain, but they can't make rational decisions or they're not able to communicate. We give them the appropriate treatment, which would be glucose in this particular situation. And as they come back online and they're able to make that rational decision, they can also choose to have no further care. They don't have to go to the hospital just because you responded if you've done the appropriate treatment and it's mitigated the immediate life threat. Minors and consent. Parents or legal guardians give consent. And in some states, a minor can give consent. And this can get really tricky in regards to who's considered a minor, who can consider themselves the legal authority on whether or not they're going to have any medical treatment. In New Mexico, a child that is 14 years of age can choose to refuse any medical treatment at a facility. In the emergency medical standpoint, in regards to EMS or fire responding to them, they have to be 18 to refuse that service. Now, you can have the occasional minor who is emancipated, and that means that they've legally disjoined from their parents and become a quasi-legal adult. They could be married to an adult and pregnant or with child. So again, this is one of those ones where we get really deep into the weeds of legalities. So in some cases, you may show up and have a legal minor who is also with a child. That legal minor can make medical decisions for their child, but they may not actually be able to make medical decisions for themselves in regards to the 911 system. So make sure that you look at your protocols, both state and local, and really understand the nuances of what's happening. Again, in our particular state, at 14, a child can refuse care in an emergency room or in a hospital. However, they cannot refuse your treatment, verbally or written, in the 911 system. So when they're at definitive care, it's a completely different situation. And I know that this can get really ambiguous and complex, and it's worth a lot of discussion and having several conversations with medical directors and the people that make decisions in your employing department. So we want to make sure that we try to obtain consent whenever that's possible. When we have minors, you always want to try to call parents and get them to give you some kind of direction on where their child should be transported, and what kind of treatments that they want you to perform on that child. If it's a true emergency and there's no one there to contact, then you're just going to treat that patient as you would in an implied consent situation. So if I have no ability to call a 15-year-old male's parents and find out where they need to go, I'm going to use best judgment and err in the side of the best treatment possible for the patient based on their presentation and the injury or illness pattern. They're going to get transported to that particular facility that I believe is going to give the ultimate care for that patient. You're not going to be held liable for that because there was nobody that you were able to get consent from. Involuntary consent. The slide says it's an oxymoron because consent can never be involuntary. People under arrest or in prison do not lose their right to be involved in medical treatment decisions. Now, the easiest way to put this is if you have somebody who's been arrested, they still have the right to be treated for any injury that they claim to have, whether or not you can actually determine that complaint exists. Law enforcement and EMS are not able to deny somebody who's been detained medical treatment and the ability to see a provider. Now, there again is some gray areas because once you are considered a ward of the state, after you've been convicted and you're in prison or jail, now the state has the obligation to give you that treatment, but they can choose to do how they see fit. That really basically means that inmates don't get to make a phone call and call 911 and have an ambulance transport them out of the prison to the medical system. They would have to be treated by the government or whatever agency is running that particular facility. Now we're going to talk about some forcible restraint, right? And I'm going to put this out in front of us. Restraining people against their will is something that we should really, really try to make sure that we don't do very often. It's defined as the act of subduing a patient to prevent harm to themselves or to you or your partners or anybody else that's going to be in immediate contact with them. It's going to apply to people who are violent and they present that risk to themselves or others, and they absolutely need to have treatment. This could be somebody who is under the influence of some kind of intoxicating agent and they are agitated and delusional. But again, we're really, really trying to not try to do this unless it's the last means possible of getting them to the definitive care. It is legal if you believe that they're a threat to themselves or others, but you should really consult the medical director or follow your standing protocols or guidelines in regards to how that restraint should be done. Whether or not it's done with some kind of chemical additive or if it's done physically, and that's based on your protocols and the special skills that are provided to you as an AEMT. You really don't want to restrain people unless you have to, right? So if you don't have the authority, you can be held liable and criminally negligent. This falls back into our kidnapping and false imprisonment. So the right to refuse treatment. This is, again, for conscious, alert adults who appear to have decision-making capacity. And by decision-making capacity, I want to hammer this home yet again. They have to be able to articulate that they understand what the risks are for refusal of treatment. So we're going to use the make-believe scenario of you responding to a adult male who has a broken arm, and we're just going to say that you splint them and put them in a sling. At any moment, they have the ability to refuse any further treatment. So you may have splinted them and put them in a sling, and they say, I got it, I can take it from here, I don't need your services anymore. They can withdraw. That's a legal right that they have. All you have to do is be able to prove and articulate in your documentation that somebody is with full mental capacity and that they can make a rational decision. So if you allow somebody to refuse, understand that you have to document that stuff because it's usually one of the higher risk for litigation, right? That seems to be our highest risk call, is the call that we respond to, and then we do nothing for that patient and ultimately leave. If there's a negative outcome, we have to be able to cover our bases and say that we tried to do the best for our patient, and then give evidence in that we explain those risks and that that patient understood those risks and still maintained the right to refuse, and that we ultimately let them refuse. You see on the bottom of the slide it says they have to be oriented to person, place, time, and event. That is a minimum criteria. I want to make sure that everybody understands that A&O times 4 is not necessarily the proverbial nail in the coffin that says that you did the right thing. Make sure that you can get your patient to articulate that they understand the risks of refusal. They need to be able to tell you that they understand what happened to them and what those risks are, and that they are still refusing further treatment. You should always try to do the right thing, and that is try to get your patient to understand that they should seek that medical treatment, and they should seek it from somebody who's qualified and is a representative of definitive care. And you really want to make sure that when you're trying to do that, you're really trying to let them know that you want them to get the absolute best care that they can get. So it's always explaining to your patient that you're trying to do the best thing possible for them. There are some state laws that do not permit parents or legal guardians to deny treatment for a minor. And this can create a lot of tension, so to speak, right? So you can have we'll use the fictitious idea of a car accident where a child is injured, and we know that that child needs to be seen in a hospital or an ED. At that particular time, the certain states will say that that patient will be transported regardless of what the parent says, right? So if we know that that patient needs to see a physician because there's an obvious injury or illness, in some certain circumstances, you may take that patient against the parent's choice or will, and just know that there's probably going to be a lot of emotions, and the parents are going to be highly upset, and it could create some unsafe situations. If you're unable to obtain consent, document any assessment findings that you can. Note how much time you spent attempting to provide care, and then make sure that you get a patient signature with some kind of witness. Now this can change from organization to organization on what the actual minimum standards are for refusal. Sometimes we don't have a witness, and we just have to do our best to make sure that we have all of the documentation complete and thorough. If you have a patient who just refuses everything all the way down to refusing to sign your actual refusal paperwork, make sure that you have that documented as well. You always have to be able to put into your documentation that you attempted to do the right thing for your patient. So advanced directives. These documents specify the treatment if a patient becomes unable to make decisions. The biggest examples of that are living wills, DNRs, and organ donation orders. For them to be valid, it has to state the patient's medical problems, it has to have the signature of the patient, and at least one signature of one treating physician who's familiar with that patient. Even with the DNR, you have to provide supportive measures. And this means end-of-life care for comfort, right? And that would be supplemental oxygen. You could give them, in certain circumstances, pain control. We want to make sure that we're doing the things that that patient requests in a compassionate manner and never overriding their wishes. Patients can have healthcare proxies, and this is power of attorney, and there are a couple of nuances to power of attorney, right? So if a patient gives the power of attorney to a child or a spouse or other relative, that patient still maintains the right to refuse. They still maintain all of the legal rights that they would have, regardless of that power of attorney. The only caveat to that is the power of attorney becomes the direct legal order if that patient does not have decision-making capabilities. If they are otherwise competent to make decisions, regardless of who has a power of attorney, they are still legally capable of refusing. Ethical principles and moral obligations. Ethics is defined as the philosophy of right and wrong, moral duties, and ideal professional behavior. Morality is the code of conduct affecting character, conduct, and conscience. Applied ethics is the manner in which ethical principles are incorporated into professional conduct. Remember, this all comes back to the standard of care and the duty to act and how we all are going to treat a patient in their best interests. You have to meet your legal and ethical responsibilities while caring for your patient's physical and emotional needs. You have to practice absolute honesty in reporting, which means that if you make a mistake, you should report that you made a mistake. And if you didn't make a mistake, you have to make sure that all of your records are accurate. And there is an ethical and moral responsibility for you to maintain a mastery in your skills. Most of our skills are considered perishable. If we're not practicing them, we tend to have less and less success rates at them, which could ultimately lead us to a situation where we can cause harm to a patient. So you are going to encounter some kind of ethical dilemma, and that could be just in consent or what you feel is the best outcome for your patient based on treatments and your inability or ability to actually provide those treatments. So remember that this is something that we all struggle with. It's going to come back time and time again, and that you're not alone in that situation. Confidentiality. This is going to lead into HIPAA, right, which is a legal document that maintains confidentiality between yourself and your patient. So if you are treating somebody, that person has the right to have any and all treatments, assessments, diagnoses, and their divulgence of anything that they have underlying conditions is going to be considered private and confidential. If you release that information to anybody that is not directly related to their care, then you can be held liable. These records can generally only be released by the patient if they sign a release, if a legal subpoena is presented, and if you're sharing treatment information with a third-party billing system. The health agencies concerned with the diseases that may affect the population. So if there's a requirement to report because you've run into something that the state says, I have to know about this, then you're allowed to give the state that information. And anything like seizure activity that might have to be reported to the Department of Motor Vehicles. In the case of cause or rape or abuse, the improper release of confidential information or release of inaccurate information can result in liability. Again, think back to slander, libel, any of those things. You want to make sure that you keep any kind of negative connotation that is not legally permissible out of your documentation, and you absolutely want to keep anything that you do write confidential between the patient yourself or the patient and the other party that's continuing their care. You should only document objective findings. There should never be any kind of opinion in your documentation. HIPAA. This is the Health Insurance Portability and Accountability Act, and it contains a section on patient privacy that strengthens privacy laws. It's guidance on what information is protected, the responsibilities regarding that protection, and the penalties for breaching that protection. All patient information is protected. Right? So any documentation that you have on any encounter with your patient is protected by law. You cannot let that just go out into the public. It cannot go to anybody that does not have any kind of legal right to see any of their documentation. Records and reports. Any action that wasn't recorded is not performed. And so in your documentation, you always want to make sure that you record everything that had happened, anything that was objective in your assessment, and anything that you didn't do, you should have some reason or rationale for why you didn't do it. Incomplete or untidy reports that you are not giving complete or expert emergency care. Right? So what we don't want to do is have you willfully omit something out of your report, because that can lead to some kind of criminal negligence if it looks like you willfully stepped outside of your protocols or your scope of practice. And in general, if you don't have a really nice, clean report that follows some kind of standard, it looks like you're not professional and that you don't have the level of training that you should have. So you want to make sure that anything that you have in documentation looks presentable and that it looks like it's professionally done. So mandatory reporting requirements. Now there's a long list of these and they vary from state to state, so this is going to be a very general and vague set of guidelines, but any abuse of children, right? And so that's any person that's under the age of 18, if they're neglected or abused, you have a duty to report that to the appropriate authorities. Anybody that is older than 18, that is going to become an adult protective services. If there's domestic violence, we have a duty to report that to the law enforcement. And if there's any kind of injury that happens as a result of somebody committing a felony, we want to make sure that we report that as well. That applies to the hospitals that have to report gunshot wounds or anything like that. Drug-related injuries, that's a state-by-state case. That is something that our particular state doesn't require us to actually report. Childbirth has to be reported, right? We want to make sure that everybody knows that a child was born and that there's some kind of accountability for that now living being. Rape is a state-by-state case. There should always have some kind of law enforcement involved in that. Whether or not it goes beyond the initial interview with the law enforcement is a different case altogether in New Mexico. Animal bites are absolutely required. Anybody that's bitten by any kind of animal, that needs to be reported. It's in the state database, and there are certain communicable diseases that are mandatory reporting so that we can track any of those that may turn into a significant threat to the population. So, scene of a crime. You want to notify your dispatcher immediately if you believe that a crime was committed at the scene. And this might be something where we show up to domestic violence and somebody has a stab wound. You want to make sure that if you already don't have law enforcement there, you want to make sure that somebody knows that we need law enforcement there. If it looks like somebody was injured because they were breaking into a home, we'll say like they punched out a window and they've lacerated their arm significantly, you want to make sure that that is followed up by some kind of law enforcement. You need to provide care to your patient, but you absolutely want to make sure that you preserve as much evidence as you can. Right? So we don't want to go stepping around and breaking things up or trying to clean up messes that are not necessarily need to be cleaned up. So don't disturb things. If somebody is in cardiac arrest, you should always attempt the resuscitation regardless of what you think the issue was. So in this case, if you have somebody who's committing a crime and another person defended themselves, and we'll just use like a gunshot wound, if your now patient is in cardiac arrest, you have to attempt the resuscitation regardless of whether or not you feel like they were a criminal. If the death is obvious, in some cases you can cover the body and you can prevent disturbance. In our particular locality, most of the time, any death, the law enforcement agencies prefer that we keep those bodies uncovered until OMI shows up and there's a complete and thorough documentation of the scene and that they understand that there's absolutely no foul play. So physical signs of death. Generally, there's a protocol for most agencies or areas that show that there are obvious signs of death, and that means that we have an obvious decapitation, an obvious exsanguination, or that the patient is bled out, or that we have a head injury of some sort that has enough brain matter that's left the skull to be obvious that that patient is deceased. Now, outside of those very specific parameters, a physician is going to determine the cause of death. And we are going to say that death is defined as the absence of circulatory and respiratory function, and there are some states that have brain death provisions. If the body is warm and intact, initiate emergency medical care, so long as it doesn't meet any of the previously mentioned guidelines in our local area. Presumptive signs of death are pretty adequate, and we've already discussed those just a few seconds ago. So now we're looking at a picture, and this is presumptive signs of death, and what you can see is the pooling of blood in the skin from when somebody went into cardiac arrest and they were laying on their back. That discoloration along the back is called livor or livor mortis. We want to make sure that somebody doesn't have a pulse, they have zero eye movement, which includes any kind of pupillary response. There's no blood pressure if they have no pulse, and their lowered body temperature. They don't necessarily always have to have a lowered body temperature if it's really warm in the ambient air. So again, decapitation, lividity, or rigor. And rigor is the tensing of small muscles, or in some cases the larger muscles, to where we have an inability to actually move or flex any of the joints in the body. So the medical examiner will be notified of any death in the field that we ultimately did not transport. They are going to come out for anything that's of an unknown cause or even a known cause to make sure that they have the documentation that goes with the state agency. If there's a suicide or a violent death, poisoning, or the suspicion of a criminal act. Also in the death of a child. So again, OMI is almost always going to come out to your scene. You may not be there. You may actually terminate care and leave that expired patient with a law enforcement officer, but they will come out and do an investigation before the patient is ultimately moved to either the OMI morgue or to a funeral home. Organ donors, so that's an express wish to donate organs. The consent is voluntary, it's informed, and it's evidenced by a donor card or a driver's license. In the state of New Mexico, you are automatically assumed to be an organ donor unless you choose otherwise when you're renewing your driver's license. And the idea here is don't get lost in the fact that they're an organ donor. We still have an obligation to try to save that patient, right? We're not going to purposely or willfully neglect any kind of duty because their organs are going to be very valuable to other people. We want to try everything that we can to make sure that we save that person. And in the event that they have experienced death, then the hospital will be the one that sets that up for the organ donation. Medical ID bracelets or other insignia, so that can be a bracelet, necklace, or a card, which indicates DNRs, allergies, if they're diabetic or epileptic, or other conditions that may warrant them incapacitated or unable to communicate their illness. So if you see jewelry, check and see if you can find anything that gives you a clue to what might be going on if they're not able to communicate with you directly.